Hi there, and welcome to our video on how to understand your legal obligations and fiduciary duties as a real estate agent acting in New Zealand. There are many things that can go wrong during the sale of a fee simple property. Issues with disclosure, marketing, forming contracts, and payments can result in a tarnished reputation or even legal action. Today, we will discuss how to avoid these issues and complete a smooth, problem-free experience for yourself, your vendor client, and any prospective purchasers. When you first engage with a vendor client in a fee simple property, it is essential to clarify the importance of being as open and as honest as possible so no potential complications will arise in the future. It is also your responsibility to illustrate the consequences of non-disclosure. If important details are failed to be disclosed, the buyer can look to seek legal action against the vendor after settlement. For example, the penalty of suspension of Ms. Prasad's real estate licence, and she was proven incompetent under Section 73B of the Act, which highlights the importance of trust and honesty in the property industry. She failed to inform any prospective purchasers of the road widening that was occurring in front of the property. Another example is Mr. Singh being in breach of Section 136 of the Act, as the vendors were entitled to know other benefits that the licensee had to gain from the transaction, but he did not disclose this to the vendor. If you ever look at Clause 10.7 of the Real Estate Agents Act, it states that you must disclose defects you know of and a reasonable person must be aware of, like a leaky house or asbestos. It is important not to forget a fiduciary duty is owed to the vendor as well as the purchaser. Failure to notice such defects could you see in legal trouble, so you must be careful whilst selling a fee simple property for a vendor client. Lastly, it is important that you disclose any previous dealings with the vendor to avoid a conflict of interest arising. Now your property is ready to be taken to the market. How you should advertise your property is up to the instructions of the vendor, and you must act in their best interest to reflect their wishes. A key thing for you to remember is that you must pop your name and that you are a registered, licensed agent on any advertisement, which in fact can be placed in a variety of places, including offices, websites, social media, signage, and any documentation. The advertised price must be what your vendor client wishes, and anything you claim must be able to be supported in accordance with the Fair Trading Act. Basically, you are aiming to attract rather than mislead through your efforts of advertising. Next up, we have the offers process. When a potential purchaser begins lodging offers for the sale of property, it is key that you record these offers and keep the vendor client informed of these in a timely fashion. If an agent is engaged in the sale of the property, they are legally obliged to hold any records of offers for 12 months. It is essential to remember that before any purchaser enters into the agreement, you must make sure you recommend for them to seek legal advice and let them know that they are able to seek other technical advice if they need it. If what you have recommended to them comes at an expense, it is in your fiduciary duties to seek the best value for them to obtain this advice. The next milestone we need to discuss is the entry into the sale and purchase agreement. When planning the entry into a sale and purchase agreement, there are some crucial factors that, as an agent, you must consider. You must ensure that the vendor and the purchaser have completed all the relevant documents and guarantee that they are ready to be reviewed. The second factor that you must take into consideration is regarding the client's terms. Under Section 9 of the Real Estate Agents Act, the licensee must act in the client's best interest. You have the responsibility to ensure that the chattels have been correctly identified in the sale and purchase agreement. This will ensure that no conflicts will arise between the purchaser and vendor upon settlement. You owe a fiduciary duty to the parties involved. Payment of the deposit for the property is another milestone that needs to be addressed. You will need to ensure that the payment of the deposit is made on time. You will also need to make sure that the deposit is made to a stakeholder, which is a neutral person that acts for both parties, and this could include you as the agent. By law, you also need to ensure that the deposit is held for 10 working days unless the sale goes unconditional and both parties agree that the deposit can be released to the vendor. In most circumstances, it is likely you'll collect your commission from the deposit which the purchaser has paid. There are a few exceptions about the payment of the deposit that you must be aware of, including court orders and authority instructions. The settlement date will be specified in the sale and purchase agreement either by a written date or a calculation from the agreement signed. This date represents when the purchaser can move into the property and the keys are handed over, and is important for you to ensure that all relevant payments have been made by this date. Thanks for watching and good luck with your next sale of a fee simple property in New Zealand. Bye!